welcome to the podcast. I'm your host, Vaibhav Khandare. In today's episode, we are going to look at various theories of justice reflected in Indian judgments. I'm purely talking about the judiciary and how the judgments are made in India, Indian judiciary, that is, and what are the various theories behind those judgments. We are not going to look at other theories which are not in terms of Indian judiciary but are there otherwise, and I will be explaining them to you. Just someone like John Rawls' theory of justice and all. But here, surely, we are going to look at various theories of justice reflected in Indian judgments. Introduction is that in India, from the very old period itself, justice was followed and it was even considered to be the very embodiment of God itself. Its soul's mission was to uphold justice, truth, and righteousness. Vedas also demonstrates its deep commitment towards justice. Manu, Yajna Kavya, etc. also shed light on the nature and quality of justice, which was followed in the ancient India. With the advent of the Britishers, they followed the status quo and didn't go for the much altercation to the laws enacted by Hindus and Muslims because they simply wanted the money. So they found it convenient to not interfere in the dharmas of Indians, that is Hindus and Muslims. But in fact, it was during the colonial period the Britishers drafted law embodying substantial and procedural justice, where ideas of rule of law, freedom of person, civil liberties, natural justice, and equality were reflected. Uh, Later, with the enactment of the constitution, this became law of the land, which is evident from the preamble, part 3 and 4 of the constitution. So, theories of justice and Indian judiciary, when we see it, as Cortozo has rightly stated in his book Nature of Judicial Process, that a judge may be influenced by his conscious and subconscious factors in arriving a judgment, and he may even consider various theories of justice as propounded by Western philosophers during the same. Judiciary, which is said to be the independent organ of the government, has indeed taken effective efforts to reflect various theories of justice as propounded by various jurists in their judgments. Such theories of justice includes Bentham's utilitarian theory of justice, Herbert Spencer and Immanuel Kant, we know them. Their theory of liberty of individual.
Okay.
Then there is Dawkins' right thesis, then Rawls' theory of justice, Amartya Sen's idea of justice, and socialist, Gandhian, and natural principles of justice. Hence, a brief analysis of the same is also important, and we are going to discuss them in brief. We are going to take a look at the analysis. So, we are now going to discuss all those theories and the judgments. So, first of all, we are going to look at Rawls' theory of justice. Now, John Rawls was a famous political philosopher in America, in USA.
Okay.
And he has propounded the social contract theory, and he points out that the justice is the first virtue of social institution, unquote. He has said that justice is the first virtue of social institution. Rawls' theory of justice, which inculcates the issue of liberty, social equality, democracy, etc., can be evidently witnessed in Indian judgments. Now, which are they? For example, we take here the State of Madras versus Champakam Dwarai Raja. It was the main case on this point, after which the first amendment to the constitution followed. There is also another case which comes to my mind is Indira Sonia versus Union of India case, and it was then the landmark judgment. It also is, whereby reservation of jobs for the backward classes was upheld. The idea of equality through protective discrimination for ensuring justice was further followed in number of judgments, even in the judgments of Nagaraja versus Union of India and Jarnail Singh versus State of Gujarat, and various other cases. The principle of distributive justice, as we say, which dates back its origin to Aristotle and as emphasized by John Rawls, has been enshrined in the Indian Constitution, article number, tell me? Yes, it is 142 and 144, along with part 3 and 4 of the Constitution. Now we are going to take a look at Dawkins' right thesis. Now, Ronald Dawkins, in his book Right's Thesis, emphasizes the importance of the rights of the individuals, upholding the common citizen's right and liberty to hold public meetings on streets and the extent to which the state could regulate it. Himmat Lal K. Shah versus Commission of Police marked an important decision in upholding liberty ideals of justice. The individual's right to dignity was reinforced in Bhagat Singh, Satwan Singh, Cooper cases, and the famous one, Maneka Gandhi versus Union of India. These were the judgments which marked the paradigm shift towards ensuring individual dignity even in the cases where the rights of a person is affected. These were the judgments which marked the paradigm shift towards ensuring individual dignity even in the cases where the rights of a person is affected by the procedural establishment by law. Judgment thereby also included substantial justice along with procedural justice. Principles of due process of law of US Constitution was thereby interpreted to the Constitution under Article 21. Now let's discuss libertarianism and justice. Yay! Libertarianism is strongly valued for its individual liberty and freedom, and it is related to the classical liberal traditions of John Locke. Then there is David Hume and Kant, etc. In Nalsa judgment, the court referred to Kant's 225 years old principle of free will and hedonist utilitarianism by Bentham, and stated that in the present case there still exists no dichotomy between individual freedoms as against public good, and has upheld the right of the third gender persons. It was followed in the Navtej Singh Johar versus Union of India, striking away the draconian law of section 377 of Indian Penal Code. In Shaira Bano versus Union of India, yes, we are getting there, the famous case, enforcing equality, the instant triple talaq was struck down by the court. And also in Joseph Shine versus Union of India, the Supreme Court of India, in its landmark judgment, held that adultery would no longer be a criminal offence under Indian law, outstripping 158 years old law of section 497 of Indian Penal Code. It is time to discuss some utilitarian theory of justice. Jeremy Bentham propounded this famous utilitarian justice theory, where he claims that the law should be enacted with the prime objective of providing maximum justice to the maximum number of people. Public utility is thereby determined through the hedonistic calculus. This was portrayed in Olga Tellis versus Bombay Municipal Corporation case, where Chandrachud J., that is Honorable Justice Chandrachud, applied this doctrine and explained the concept in the brief statement, quote, "Human compassion must soften the rough edges of justice in all situations." This statement is itself very valuable in terms of how the judgments are made and what outlook should the court follow. The court ruled through the eviction order is valid under Article 14 and 19 of the Constitution. Yes, the right to life was enlarged to engulf the right to livelihood as part of liberty of an individual. Court thereby focused upon the concept of welfare state. Referring to the Hume's theory of justice in Union of India versus Tulsiram Pathak case, the court underlined that the public utility is the sole origin of legal justice, and for the useful legal system, it must adhere such rules, even though it may cause injustice in particular cases. In a Bangalore Medical Trust case, also the principle of public utility was pointed out by court in preferring public parks over hospitals. Now we are going to take a look at Amartya Sen's theory of justice, the famous one. Amartya Sen propounded the social choice theory, whereas he stated that the law should be enacted understanding the needs of the society and should be based on demand of justice. Recent landmark judgments of Puttuswamy versus Union of India, apart from dealing with privacy, it also dealt with many other aspects. It invoked the writings of Amartya Sen's idea of justice and stated that the political liberties and democratic rights are the constituent components of the development. Justice Chandrachud even overruled his father's judgment in ADM Jabalpur versus Shivakant Shukla. His father is from my college. Okay, and thereby upheld the dissent of Justice Khanna, and thereby the recognition of right to life and personal liberty under the constitution. In 2010, Pradeshiya Janjati Vikas Manch and others versus State of UP and others referred to Part 4 of the Amartya Sen's idea of justice, public reasoning and democracy in ensuring the civil and political rights of the scheduled tribe and person's right to representation at the grassroots level. B.K. Pavitre versus Union of India referred to Amartya Sen's merit and justice in understanding merit as an instrument in achieving social ordering and in lessening economic inequality. Court thereby ruled that providing reservations to SCs and SCTs is not at odds with the principle of meritocracy. Court ruled that merit must not be limited to inflexible criteria such as ranks in exam, but seek to provide equality in society. This judgment is a landmark judgment, and if a student is finding it hard, the policy of reservation and why it is there and the justification behind it, then they can certainly study the court's various judgments, and you can also study Amartya Sen's theory of justice on a lighter note. So now we are going to take a look at the most important theory, and which is also discussed vividly in the legal circle of India, which is a basic structure theory. After the enactment of 24th, 25th, 26th and 29th Amendment of the Constitution, their validity was challenged on authority of Goloknath judgment in Keshwananda Bharti versus State of Kerala. But Goloknath was overruled and the basic structural doctrine was upheld by the judiciary, where the basic structure has not been still defined and is enlarged to include many of the rights of the individual which cannot be abrogated by the parliament. Indira Nehru Gandhi versus Raj Narayan upheld the independence of judiciary in dispensing justice and held that judicial review is the basic feature of the constitution. Consequently, after 1976, Supreme Court took considerable efforts to bring a new egalitarian order in furtherance of directive principles of state policy. Thus, in Minerva Mills case, the famous Minerva Mills case, Court underlined that Part 3 and 4 of the Constitution is like a twin formula for achieving the social revolution. So, if you are to understand the social justice and how the government thinks about it, then go in there and study the Minerva Mill case. Now, the Gandhian theory of justice, we are going to take a look at it. It is based on the principle of truth, equality and social justice. The concept of Lok Adalat is an innovative Indian contribution to the world jurisprudence and is based on the Gandhian principles. It was so held in the case of MP State Legal Services Authority versus Pratik Jain case. So coming back to the conclusion of it all that we discussed, there may exist no society without justice, and the concept of justice conditioning and individual responsibility plays an important role in theories of justice. Along with the analysis of these judgments, where we can observe the reflections of various judgments, in addition we have seen the judicial activism of the court many a times, and these lawmaking functions of the court can be traced back to the realist school of jurisprudence, which can be said in line with the Austinian concept of command over the sovereign, whereby here judge is considered to be the supreme in setting law in legal right. It can be said that judgments are the very embodiment of justice, where we can observe various theories being reflected there. Today's episode is very important in terms of jurisprudence. You may have the basic idea in here so that it will be easy to understand jurisprudence. I hope I was understandable. Suggestions are welcome. I hope you like it. Thank you and have a nice day. And remember, law is in the air.